Welcome back to another Pearl Lemon Legal YouTube video, and today we're going to be discussing how to recover your debt without the use of a solicitor, and we'll be giving you a step-by-step guide to do so. Now, fortunately in the UK, it seems many individuals and businesses are constantly seeking to claim loans, invoices that were unpaid, services that have been rendered and not remunerated, and so this is a clearly defined, easy to follow process which we will be walking you through today. So number one, you want to assess the debt. What's the amount? Did you have an agreement in place? Is it a contractual agreement? Is it a service level agreement? Is it something that was said over email, something that was said verbally? And then you want to begin by collating all that evidence, the bank statements of the amount, the invoices you sent, the receipts, any sort of correspondence via email with the other party, and go from there. Now, the next thing you want to do once you've done the above is to open the lines of communication. You don't want to start with legal action. You want to give the other party a formal opportunity to settle the matter by returning the amount they owe to you. This should normally be done by email, just to keep everything in the same place, to have it be admissible in court, and to ensure that you get an answer in writing. Now, after that, you may need to look at drafting a letter before action. Now, letters before action have got a very clearly defined format. These can be found online, or you could speak to a legal consultant such as ourselves or a solicitor for a bit of advice. Generally, the things you want to ensure are the date that you're sending it, your address, the address of the other party who owes you money. You want to include a subject line, and then the content of your letter will determine what the debt is for, what action you'll be taking against them. You're obtaining a CCJ, a credit default. You may make reference to specific legislation. If it's a consumer issue, you may even make reference to the Consumer Rights Act. You may make reference to pre-action protocol, just to substantiate why it is you're taking the action you are. And then you want to give a timeline for a response or repayment. Now, what will follow next is the procedure to go to court. You'll need to have submitted a claim form. You will need to have your evidence collated, and you'll need to be ready to substantiate why the other party owes you money. Now, this is where you would get to preparing your case. And you've already started to an extent. You've communicated over email, and so you have a trail where there's proof of an agreement if there wasn't one already. You will want to include any evidence of an agreement. You want to include invoices. You want to include bank statements or proof that there's been a lack of payment. And you'll want to include any correspondence, including your letter before action, going forward. You may also want to include the particulars of your claim, which is a document or a witness statement. Both documents would detail or summarize more or less what has happened up to that point. Now, you would look at filing your claim, and this is where it does confuse certain people, although it is not necessarily a very complex issue. It's simply identifying the correct form. Now, if your claim is for less than £10,000, you would be using a Form N1. If it is a claim for above £10,000, you may want to look at using the Form N181, which is the fast track claim, and that's what you could use for your larger claims. Now, those forms do give you a little bit of information as to what to include. It'll ask you a few questions, and generally are fairly self-explanatory. Although, again, we do find certain individuals need a little bit of extra support. It can seem overwhelming, and there is the concern that a mistake would cause the form to be sent back and another administration fee be levied. Now, you'd look at attending the hearing. Now, this is something we've discussed before, but generally you want to approach the court in a business-like, formal manner, using polite language, presenting yourself professionally, and simply avoid any overly emotional displays, as this will negatively affect your case. Now, if you follow these steps, more or less, you've been successful. You've obtained a legal claim against the other party. You might be wondering, what now? They haven't paid me back yet. So at this point, you would be able to enforce your claim by using bailiffs. Now, bailiffs would approach the defendant's home or place of business, and they would have a legal duty to claim assets to settle the debt, or have you pay the amount at the time that they show up at your door, or rather the defendant's door. And there you have it. That was a brief step-by-step guide as to how to recover your debt without the use of a solicitor. We hope you enjoyed that. We look forward to seeing you in our next video, and we'll catch you then. Stay legal.